All right. Hello, everyone. Welcome in. Thank you for moving with alacrity to this next session. And we're in for a real treat, at least as much as it can be a treat to talk about the administrative state. People sometimes ask me, what are the biggest threats to religious freedom in the United States? And my answer is, first, boycotts. With social media and with just the speed of information and the way social passions tend to cascade so dramatically, you can imagine that a sports team, for example, visiting another university, students get angry and there's a boycott and it can result in significant damage. The second thing I talk about is licensing and accreditation. These kind of quasi-governmental organizations that are given enormous power and can actually be captured by interest groups. And whether it's a licensing organization for psychologists or lawyers or accountants, you can imagine a world where if people don't go along with certain prevailing cultural majoritarian views, that they could be excluded from the ability to practice a profession. And then there's, of course, the administrative state, which, through its regulatory power, does a lot of legislating. When we think back, for example, to the Bob Jones University case, it was the IRS that came up with a new policy. It wasn't a new law that was passed. It was the administrative state. And whether you agree substantively with the outcome of that or not, the power of the administrative state can sometimes worry us. And then further down the list, I put tax exemptions. A lot of people think that's the biggest threat. You're going to lose your tax exempt status. That would be devastating for any religious group. But I actually think it's about number 4 or 5 on the list. And what we're going to be talking about here today are things higher on the list of potential threats, and in some cases, as we'll hear today, actual threats. We have 3 extremely qualified and knowledgeable experts to guide us through our discussion today, and I'm going to let you use your QR code to read their bios and not spend time on that. But we're going to hear first from Rachel Morrison from the Ethics and Public Policy Center, who's going to talk about non-discrimination. A great concept which we all love, but which can create certain unintended or perhaps intended consequences that can be troublesome. We're going to then hear from my friend and mentor, Gene Schaerr, from Schaerr Jaffe LLC, also teaches at BYU Law School. And he's going to talk about these issues of accreditation and also issues that arise within the administrative state at places like the Equal Employment Opportunity Commission, the National Labor Relations Board. I think of this as the alphabet soup of Washington, D.C. And I don't much like alphabet soup, but believe me, the alphabet soup of Washington, D.C. can be even less savory than the old Campbell's version that you perhaps enjoyed as a child.
It's why it's so hot there.
And then our third speaker will be Shawn Gunnarson from the law firm Kirton and McConkie, and he's going to talk about how do we defend ourselves against some of the threats that will be discussed by Rachel and Gene. We'll ask our panelists to be a little brief. We may have time for a little bit of Q&A at the end. We may need to ask you to come up and talk to our panelists during the break. But Rachel, first over to you.
Thank you. It's great to be here, and it's great to see so many people in an administrative state panel, standing room only in the back. As Brett said, the administrative state poses a lot of problems for religious liberty, and this is because most of the laws and regulations that affect us in life come through federal agencies. They don't actually come through Congress and our elected officials. And as federal agencies regulate more and more all aspects of public and private life, there's more and more opportunities for conflicts with religious freedom. So today I'm going to provide a brief survey of Biden administration regulations that impact religious freedom work, or religious freedom that I've seen in my work. So most of these regulations stem from the Biden administration's policy priorities for abortion and LGBTQI plus agenda. And so these policies can pose conflicts or be in tension with various religious beliefs to varying degrees depending on your religion, and different groups to different extents, especially those religious beliefs about fundamental things like life, marriage, gender, and sexuality. So the policies that broadly are being pushed by the administration that I've seen have posed religious freedom concerns for various religious groups are the provision or facilitation of abortion or medical gender transitions, contraception, fertility treatments, insurance coverage for those medical interventions, employment protections based on abortion, sexual orientation, or gender identity, pronouns based on identity, and then allowing access to sex-specific spaces based on gender identity. So at the same time, the Biden administration is pushing these policies through a lot of different rules and regulations that I'm going to mention in a minute. It's also taken steps to minimize protections for religious freedom and conscience for religious folks and organizations, especially regard to these policy priorities. So there's three main types of regulations that I've seen where these policies show up. The first is government benefit regulations. The second is regulations on existing non-discrimination laws. And the third are regulations imposing strings on the federal government, imposing strings on federal government funding. So I'll address each in turn and provide some examples of various regulations of how this has come up and how the administration has treated religious liberty in some of these. So the first, regulations involving government benefits. So this is the federal government providing benefits to a group of people. So some examples of these regulations are Veteran Affairs and Department of Defense rules that provide abortion and gender transition coverage for the federal employees and veterans and military members and beneficiaries. And so this can pose religious liberty concerns for federal employees who have to administer these benefits or facilitate those benefits. There's also an HHS, a Department of Health and Human Services, unaccompanied children program rule that requires facilitation by the Office of Refugee Resettlement of abortion and gender transitions for unaccompanied children. So the second category, which is the largest category, is existing non-discrimination laws. So a lot of the Biden administration's policies are being pushed through a redefinition and expansion of sex discrimination laws to include sexual orientation, gender identity, and then also abortion or other reproductive decisions such as contraception or fertility treatments such as IVF that can pose religious liberty concerns for certain folks. So examples of this are the Title IX rule, which prohibits sex discrimination in federally funded educational programs and activities. Jean's going to talk a lot about that. There's the HHS Section 1557 rule. 1557 is the non-discrimination provision of the Affordable Care Act that prohibits discrimination on the ground prohibited under Title IX, so sex in federally funded healthcare programs and activities. This rule mandates that doctors need to provide medical gender transitions and that insurance needs to cover these medical gender transitions. And if you have a religious objection to providing gender transitions, that doesn't matter. That's still discrimination and it's still prohibited under the law. Now we're moving to the Equal Employment Opportunity Commission. They have a recent rule on the Pregnant Workers Fairness Act, which was supposed to provide workplace accommodations for pregnancy, childbirth, or related medical conditions. But the EOC has interpreted this to expand to abortion, contraception, and fertility treatments. In the rule, they took a very narrow view of any religious defense that a religious employer could raise, objecting to providing accommodations for those medical interventions. They interpreted Title VII's religious organization exemption, which is incorporated into the Pregnant Workers Fairness Act, as only applying to claims of religious discrimination, which means it would not apply to claims of pregnancy accommodation. EOC has also historically taken a narrow view of the Religious Freedom Restoration Act, and they were on the wrong side of both ministerial exception cases at the Supreme Court, Hosanna Tabor versus EEOC, and then they argued against the Catholic school in Beale, which was the companion case to the Our Lady of Guadalupe versus Morrissey Baru. EOC also issued Title VII harassment guidance. This is technically not a rule and technically not legally binding, but is extremely persuasive in what the EOC is going to use for their enforcement actions. And so there's litigation right now about whether this is a rule or not a rule. But in practice, it functions like a rule in a lot of ways. So this says that sex-based harassment extends to sexual orientation, gender identity, and how that identity is expressed. It's harassment if you don't use someone's preferred pronouns, if you misgender someone, if you don't allow someone access to a sex-specific space based on their identity. It also takes an expansive view of pregnancy, childbirth, or related medical conditions, which could also pose some concerns for religious organizations or religious employees. We also see a push to extend disability discrimination laws and protections to gender dysphoria, which is another way to bring in some of the gender identity non-discrimination policies, but through a disability discrimination law. The administration, through the Department of Health and Human Services, issued a disability discrimination rule that said that Section 504 of the Rehabilitation Act and the Americans with Disabilities Act applies to gender dysphoria, even though that law has an exclusion for gender identity disorders not resulting from a physical impairment for the definition of a qualifying disability. This theory is being pushed by DOJ through various guidance letters and litigation. And then there's the HHS conscience rule. And so this involves over 24 conscience protection laws, mostly in the healthcare space that HHS enforces. This rule deleted definitions and enforcement procedures from the Trump-era rule while saying that it was providing clarity and protection. And then it suggested that these laws must be balanced with other rights, such as non-discrimination rights, even though these laws themselves don't contain balancing tests. This rule, in context, is a very ominous sign because HHS has taken steps to stop litigation to enforce conscience protection laws for a nurse who was forced to perform an abortion in violation of her rights. They also stopped enforcement action against the state of California for forcing nuns and others to provide insurance coverage for abortion. So even though these conscience protection laws exist, if HHS doesn't enforce them, there are no protections in practice. So the third category is government funding strings, so policies that come through non-discrimination strings on the receipt of federal funding. So there's various rules by agencies to impose non-discrimination in order to participate as a contractor or to provide social services to others that various agencies want to propose. These rules take a very narrow view of protections for religious organizations and the ability of those religious organizations to make hiring decisions based on religion. There's also an HHS foster care rule that says placement of LGBTQI plus identifying foster children must be affirming and supportive of the child's identity. When it comes to a religious provider who wants to care for these children, if they're not affirming or supporting of the child's identity and providing them access to services and supports, they can't work with those children. In theory, they could work with other children if the state lets them, but HHS left that up to the state to determine. The underlying premise of that rule is that if you aren't affirming, it is unsafe, mistreatment, abuse, and harassment, even if it's for religious reasons that you cannot affirm a child's identity. And then finally, there's state foreign assistance non-discrimination rules that would impose additional non-discrimination strings in order to provide foreign assistance. There's a potential for a religious waiver for contractors, but it's not guaranteed. And so this leaves a lot of question marks as whether these contractors and others can continue to provide foreign assistance in the country once these rules are finalized. So who do these policies affect? I think there's kind of 5 broad categories. There's federal government employees. There's faith-based organizations that partner with the federal government to provide social services and foreign assistance. There's religious employers and businesses, and kind of a subset of that, there's religious universities, which Jean's going to talk about. There's religious employees at secular, non-religious organizations and businesses. And then there's religious students as well, which have, I think, the minimum amount of protections under law, actually. So many of these concerns and the conflicts with these regulations were raised during the public comment process and the rulemaking process by myself and others that care about religious freedom. We raised concerns under the First Amendment, under the Religious Freedom Restoration Act, under statutory protections such as Title VII, Title IX, federal conscience protection laws. So what has the administration done in response to these concerns, especially related to these policies? In one sense, they've started to take religious freedom concerns more seriously, at least in word. I think some of this stems out of the litigation with the Hobby Lobby case and the contraceptive mandate. They realize they can't just ignore it and it'll go away. So they've started providing some more protections in the regulations themselves for federal employees and acknowledging that federal employees have protections from providing abortions or gender transitions, and they won't be forced to, or there's an accommodation process that they can go through. So we've seen some improvements on that regard. There's also been some improvements in identifying a process of appeal for a religious accommodation or an exemption determination. Who do you reach out to? Who evaluates it? It's not good enough. I don't think it provides enough information, but it's better than nothing. So there has been some movement in response to concerns and comments in that way. And then finally, there's promise in many of these rules that we will honor our obligations to comply with the First Amendment, RFRA, these other conscience rights, religious freedom protections, but we're not going to opine on any specifics because these are all fact-specific scenarios. They all need to be determined on a case-by-case basis. This case-by-case basis appears to be an effort to avoid pre-enforcement challenges to the rule. This was raised in a legal challenge to EOC's Pregnant Workers Fairness Act of you can't challenge it right now. We have to evaluate any claims of religious defense in the future, and so you can't enjoin enforcement of the rule for providing abortion accommodations at the moment. And I think it's important to know that at the end of the day, a promise to and the ability to raise a defense in the future and to have an agency evaluate it is not actual protection in practice. It leaves religious organizations and religious individuals uncertain of their ability to exercise their religious beliefs and what the law requires and whether they can participate. It's going to lead to self-censoring, folks choosing not to exercise their religious beliefs, or opting out of programs or services, which will be a loss for society. And then just as a final thought, a lot of these rules are in litigation. There's being challenged under various religious freedom laws and grounds. And so I think we're going to get some more clarity on the extent to where the administration has to provide more clear protections for religious freedom and where they've overstepped and religious organizations and religious folks can get the pre-enforcement challenges for application of some of these policies that violate with their religious beliefs.
Rachel, thank you. That was sweeping and comprehensive. Virtually every point you made could have been its own lecture, or you covered a lot of ground, and it's helpful for us to get that sort of high-level overview of just the range and variety of challenges that exist via the administrative state. Jean, over to you.
Thank you. Let me begin just by saying what an honor it is to participate on this panel with three other people with whom I've worked a lot over the years and for whom I've had enormous and continue to have enormous admiration. They are all, in their own ways, champions for religious liberty. I think what I'd like to do today in the short time that we have is I'd just like to tell a couple of stories about taming the administrative state by way of trying to illustrate one thing that all of us can do to try to ensure that the administrative state does not unduly impinge our religious liberty. The first story begins in 2001 something that Brett alluded to earlier. There was what you might call a holy war within the American Psychological Association. That organization had a long-standing provision that essentially exempted religious organizations, including religious colleges, from some of their requirements with regard to non-discrimination, things that would have required religious schools, for example, to hire people who were in same-sex relationships, even if that would be contrary to the teachings of the religion with which the school was affiliated. There was a faction in the APA that made a very serious effort to delete this religious exemption from the APA's non-discrimination standards, which would have had the effect of at least putting a lot of pressure on religious organizations to hire people and admit students who were living in a way that's contrary to their teachings. And that effort was defeated only after the General Counsel of the Department of Education sent a letter to the APA, the American Psychological Association, basically telling them to back off, that if they continued down that path, they were putting their own approval as an accrediting body at risk. And who arranged for that to happen? It was the then General Counsel here at BYU, a longtime friend of mine by the name of Tom Griffith, who had lots and lots of great connections in Washington, D.C., and was sort of able to pull the right levers to get the General Counsel at the Education Department to send that letter, and they went away. But Tom didn't stop there. He thought, this is going to keep coming up again and again, and we really need to do something to fix it more permanently. And so he called me. He and I had been friends for a long time. I was at a law firm a different law firm in Washington, and I was mainly an appellate lawyer. Did a lot of work in the Supreme Court and that kind of thing. And he said, Gene, I have a legislative project for you. And I said, I'm not really much of a lobbyist or anything like that. and he said, well, that's okay. I've got a good lobbyist that I can team you up with, but you know a little bit about religious liberty, so I would like you and this other mutual friend of ours to work on lobbying for a change in the Higher Education Act that will fix this problem more permanently. And so we were very fortunate at the time to have some very friendly leaders of the relevant House and Senate committees. Orrin Hatch from Utah was either the chair or the ranking member of the Senate Health, Education, and Labor, and whatever P stands for, the Senate Education Committee, and another BYU alumnus and great friend of religious higher education, a guy named Buck McKeon, was the chair of the relevant committee on the House side. And so we went to work with them and their staffs to try to come up with something that would fix this problem. And what we ended up with was just a few words that we managed to get inserted in the dead of night into a reauthorization of the Higher Education Act. That basically it amended the provisions that apply to federally recognized accrediting bodies, and it said, in order to be a recognized accrediting body, you have to respect the missions of the organizations, of the institutions that you accredit, including, but not limited to, religious missions. Okay? And people who had been engaged in these accreditation fights, my initial reaction was, that language is kind of loose. I could drive a truck through that if I were a litigator. But the people who had been in, these accreditation fights, they said, don't worry about that. All you need is a piece of paper that you can point to and say, no. When you start asking questions about our LGBT-related policies, our policies about things like abortion, those are central to our missions, and the law says you've got to respect those missions. Just stop. And they all thought that would be enough. And so we managed to get that little provision, that mission protection language, inserted in the Higher Education Act. And And we have seen the power of that language. I've had a number of engagements for a number of religious colleges around the country who have been engaged in accreditation fights since then, and every single one of them has turned out just fine once we pointed at that language and said you're going to be violating the law and you're going to be involved in a very expensive fight for your own status as an accrediting body if you continue down that path. So the second story goes further back in time to the time in 1972 when a very important civil rights law known as Title IX was passed. Rachel alluded to this earlier. It's the law that governs education and generally prohibits invidious discrimination of various kinds. But one of the most important things that Title IX did was that it made it unlawful to discriminate against women in education, and it explicitly prohibited discrimination on the basis of sex. Now, as you probably know, the courts have taken that prohibition on discriminating on the basis of sex and sort of turn it into a general purpose prohibition on any kind of discrimination on the basis of sexual orientation or gender identity, anything sex related or even non-sex related, gender related. But at the time in 1972, there were people in Congress who realized, there's some Catholic colleges out there who believe that the Catholic priesthood should be limited to men. Okay, and so we probably need some kind of an exception to this prohibition on sex discrimination to recognize that people in some religious traditions are probably going to have legitimate reasons to engage in what the secular world would view as sex discrimination. So they carefully wrote into Title IX a little provision that expressly exempts from the coverage of Title IX institutions that are affiliated with a religious organization or a religious denomination to the extent that compliance with that prohibition on sex discrimination would be contrary to the religious beliefs or practices of that institution. And that little exemption of just probably, no more than 15 or 20 words has saved religious higher education from just enormous grief over the past 50 years or so since that law was passed, and especially in the last 20 years or so since the sexual revolution has sort of embedded itself into our national law. And Rachel has pointed out a number of other ways that the administrative state can really threaten the ability of institutions of religious higher education to act in accordance with their own beliefs and to be really who they are, right? So the point of all that, to me, is the importance of being vigilant, not just in fighting the administrative state in court, but also in curtailing or controlling the administrative state through legislation. And to my mind, it's important for people generally who care about religious liberty to try to cultivate good relationships with members of legislatures who can very quickly and easily fix religious liberty problems that might otherwise seem intractable, and they can avoid religious liberty problems that they can see coming down the road, as Tom Griffith did years ago when he was the general counsel here at BYU, and prevent a whole raft of religious liberty issues. So that's my pitch. Thank you.
Thanks, Gene. We think of trying to protect religious liberty through litigation or legislation, and one thing we've observed is that generally legislation is a better solution. And so even if you're winning fights in courts, it's going to be a temporary victory, I think, or a more all victories are temporary in a way, but it's going to be more temporary if we overly rely on courts. So thank you, Jean, for those examples of how sort of the legislative process can be a counterweight to sort of the administrative state. Shawn, Gunnarson, over to you.
Thank you. And again, like the others, I'm very honored to be on this panel with good friends, each of whom is doing their very best to defend religious freedom. In the few minutes that I've got, I'd like to take a different perspective than I think might be the ordinary one on the question of how we defend religious freedom in the administrative state. Now, ordinarily, we would reach for those provisions of statute, RFRA, individual exemptions, like the Title IX religious exemption that's been mentioned, and the religion clauses of the First Amendment. I've briefed all of those. They're very important. We could have an hour-long discussion about any one of those. But it struck me when thinking about this session that one question that we who are worried about religious freedom sometimes do overlook is the logically prior question, which is whether the regulation itself is even lawful, that is, if it's even a reflection of the federal government's authority to act in the first place. So in the next few minutes, I want to tell you about a couple of legal principles the Supreme Court is currently involved in that could make a real difference to people who are defending religious freedom, either for institutions or individuals. One of those developments is what many are saying will be the end of something called Chevron deference. Now, for those of you who are not aficionados of the administrative law, I will take a moment and explain what that means. A pillar of modern administrative law is a decision called the Chevron USA versus Natural Resources Defense Council. This is a case from about 40 years ago that essentially holds that when an agency is interpreting a federal statute that itself is administering, say, think Title VII or the EEOC kind of a setting. The courts are supposed to begin with a fair bit of deference towards the agency, and this happens in a two-step framework. Step one requires the court to use ordinary rules of statutory construction to decide what they think is the best reading of the statute, to see if the Congress who wrote the statute actually addressed a specific issue that's in dispute. And then if the answer is yes, Congress did actually address the issue the parties are fighting about, then a court would ordinarily defer to the agency's reasonable interpretation of the statute. Now, as you might expect, depending on how much or how little deference courts pay, that can make a tremendous difference in the ability of people to challenge regulations. What it means, in fact, is that agencies get away with quite extraordinary readings of the statute, readings that no sensible person would reach, and the court itself has sometimes admitted would not be the best reading of a statute. Well, all of that seems to be coming to an end because of a series of criticisms. Now, the court doesn't often, different justices, sort of, target an individual decision in separate opinions. Chevron is an exception. This is one of the cases that it's difficult to love. And so we've seen criticisms by Justices Thomas, Gorsuch, Chief Justice Roberts, and Justice Alito all have written separately to say, Chevron's problematic. It's not really easily reconcilable with the premises of our constitutional system, particularly the vesting clause of Article 3 that gives courts the power to exert judicial power in cases of controversies. And so there have been lots and lots of nuances attached to this, and the question really overall is whether or not this rule of deferring to an agency's reading of the statute should continue. Well, there are now two cases before the Supreme Court that will be decided in the next week that will give us an answer to that question. Let me tell you a little bit about them. Loper Bright Enterprises versus Raimondo and its companion case, Relentless Inc. versus Department of Commerce, are both, of all things, herring fishery cases. These are cases involving a regulation adopted by the National Marine Fisheries Service. And the regulation essentially requires the commercial fishermen to allow for a federal monitor on board a commercial fishing vessel to ensure that the fishing happens in compliance with federal regulation. Well, the problem with this requirement is twofold. One, NMFS has basically required these small companies, there's no sort of threshold for size or annual revenue or anything, to provide space on board their vessels, which of course takes away from a crewman that could be doing work. But more importantly, it requires the companies to pay the cost of the federal monitors. Well, what this means in practice, according to the court documents I've read, is that the average commercial fisherman loses up to 20% annual revenue by following this rule. Now here's where things get really interesting. NMFS has adopted that rule in response to statutory silence. Congress actually never specifically addressed the question whether or not herring fisheries in the Northeast have to have federal monitors on board their ships. And so the court granted two separate cases to decide, in part, whether or not this rule of Chevron deference will continue to go forward. The D.C. Circuit, in one of the cases, basically invoked Chevron deference as a reason to accept the agency's reading of the statute. And the question now is how much or how little agency deference will survive after the court revisits Chevron. Incidentally, just for those of you who follow details like this, oddly enough, the court did not consolidate these two cases, and I sort of poked around and found out why. Justice Jackson sat on the hearing as a member of the D.C. Circuit in one of the cases, in the Loper-Bright case, before she got to the court. And as a consequence, she's, of course, recused from that case. And so the court granted the Relentless case on almost identical facts in order to ensure that there's a full 9-member decision that they could evaluate. Now, let me mention a couple of things. Retiring Chevron would do a couple of good things for those defending religious freedom. The first is that we could hold federal agencies to the standards of the statute itself. That is, we could require courts to adopt ordinary rules of construction to point them toward the best available reading of the statute by applying those rules. That means that the agency doesn't get an extra thumb on the scale just because it's the body that administers the statute. Secondly, and perhaps even more importantly, is that the demise of Chevron would mean finally that courts would return to what Justice Scalia called the original design of the Administrative Procedure Act. This would mean that an important section of that act, Section 706, with various provisions I've quoted here but I'll leave alone, basically holds the agencies responsible for enacting regulations that are arbitrary and capricious, that are beyond their authority under the statute and so forth. It basically holds the agency within the bounds of authority specified by Congress in the language of the statute itself. Incredibly important for parties to be able to bring those kinds of challenges, and as Chevron is out of the way, that pathway becomes quite clear. Let me tell you about the second development. I've sort of entitled this part of my remarks, The Rise and Rise of the Major Questions Doctrine. So let me tell you the story. The Major Questions Doctrine, for many, many years, it existed at least since a 1980 case called the Benzene case, basically has said that when an agency action consists of vast economic or political power, that think of the agency grabbing power in a way that decides the really big questions, then the agency has to point to clear congressional authorization. That's the language of the Supreme Court decisions. Think of this as almost like a checkmate card. If you can show that the agency has exercised vast economic or political power, then it has to point to very specific authorization in the statute. And if it lacks that, those decisions clearly come out in favor of the challenging party. You've got decades of case law from the Supreme Court on this. But here's the really interesting fact. For decades, the pattern of the Major Questions Doctrine was you had only one, maybe two cases a decade even mentioning this idea. And they were usually in very far-reaching regulatory context. A good example was a decision from the 1990s involving the Brown and Williamson case, where you had a tobacco company challenging an FDA attempt to regulate the entire tobacco industry by way of the FDA Act. And the Supreme Court said you can't do that. The statute actually doesn't give you authority in this kind of sweeping fashion to regulate the entire tobacco industry. Various other cases have come along the pipe, but again, at very long intervals. It hasn't been a very common ruling for the court until 2020, excuse me. In the past 4 years, we've had 4 Supreme Court decisions in a row. Every single year, the court has decided a major regulatory fight under the major questions doctrine. And those cases include the eviction moratorium from the Centers of Disease Control, OSHA's vaccination rule for large employers, EPA's rule that would have basically required the entire electrical industry to do away with coal plants over time, and finally last year's decision striking down the Education Department's student loan forgiveness project. In each of those cases, what you saw was the court straining to keep the agency within the bounds of the statute, because the implications for the country of allowing the agency to favor its reading of the statute were so far out of bounds that essentially it created both statutory textualism problems, that is, the statute really can't mean what the agency has said it means, and separation of powers problems. That is, Justice Gorsuch and others have said that this is a terrible violation of the vesting clauses of Articles 1 and 2 that keep the power to make law and the power to execute or enforce law separate. Here is, I think, the overall point I'd like to make. We have a rich constitutional history, structure, and system that allows us to challenge laws when they exceed the legal bounds that a federal agency possesses. And at the same time that those of us who work with and deal with issues of religious freedom are thinking of those battles in terms of the First Amendment or RFRA or any of these particular statutory exemptions, let's also be sure to include that prior question: is the agency's action lawful at all? Thank you.
Well, we've been really well served by this panel that has educated us in a deep and meaningful way. I'm going to apologize for not preserving time for a Q&A, and thank our panel for moving so quickly through their presentations. I know each of them felt perhaps more than a little rushed. Perhaps just one closing observation. I had never really thought about this before, but the common thread I saw between each of your presentations was the distance of democratic accountability. And it seems that the further distant you get from democratic accountability, the more likely shenanigans arise. And it's remarkably difficult to stay within a statute if you're an administrative agency. I mean, think of Frederick Davies' talk earlier, where both from the left and the right, there are pressures on the U.S. Commission on Religious Freedom to engage in a type of advocacy which is important to a certain constituency, but may go beyond the statute. And it takes a fair amount of resistance and perhaps humility to stay within the bounds of what the statute has empowered us to do. So I don't know if you'd agree with that observation or not, but it seems like this idea of democratic accountability is really closely tied to the issues that each of you were raising. Let me ask the audience to simply join me once again in thanking our panel.